Before we dive into today's courtroom drama, buckle up because this case is packed with second chances, broken trust, probation violations, and a judge who clearly remembers every detail. At the center of this hearing is a woman who was originally facing serious felony allegations involving theft and embezzlement from a local American Legion. Despite the severity of those accusations, she received what many would consider an incredibly favorable plea agreement that reduced the case to a misdemeanor and kept a felony conviction off her record. But here's where things get interesting. The court gave her an opportunity to prove she could turn things around. Instead, according to probation officials, she disappeared from supervision, failed to report, failed to pay restitution, and ultimately ended up in legal trouble in another state. Now she's back in court, standing before the same judge who gave her a break the first time. The big question hanging over this hearing is simple. Was this someone genuinely trying to rebuild her life after addiction and poor decisions? Or was this another example of someone squandering an opportunity they were lucky to receive? As the hearing unfolds, you'll hear arguments from probation, emotional testimony from the defendant, and a judge who isn't afraid to speak his mind. Pay close attention because the judge's comments later in this case reveal exactly why courts take probation violations so seriously. And when the final ruling comes down, you'll have to decide for yourself whether justice was served or whether another chance should have been given. Let us know throughout the video whose side you're on because opinions on this one are likely to be divided.
To get everything squared away here. All right, we're back, and we're going to take up the probation violation matter. All right. All right. We're going to address the matter of Jayla Marie Stallard, who now goes by Wilson.
I'm sorry.
And we had talked about that when I saw her last. Miss Stallard was charged with felony larceny of building and embezzlement from the American Legion in December of 2024. Those were charged as felonies. The matter was reduced to a misdemeanor, and the defendant was placed on a probation. Ms. Ives must have really done some substantial arm twisting here to get this reduced to a simple misdemeanor under $200. She was placed on probation for 12 months, 91 days, credit 1, leaving 90 days to serve. I gave her a week, so I deferred to 83 days and some fines and costs. There's also $1,250 worth of restitution to the American Legion.
This is already a critical moment in the case because the judge is outlining the history that brought everyone back into court. Notice how much emphasis is being placed on the original plea deal. In legal terms, probation is often viewed as an opportunity rather than a punishment. Courts typically expect strict compliance because the defendant is being allowed to avoid harsher consequences. Here, the judge is essentially establishing a timeline showing that the court extended trust, imposed conditions, and then allegedly lost contact with the defendant altogether. That's a major red flag in any probation case. What stands out to you so far? Do you think missing appointments and disappearing from supervision automatically justify jail time, or should courts focus more on what happened afterward and whether someone eventually turns their life around?
That didn't work out. Daniel filed a probation violation petition, Daniel Frazine, her probation officer, last August. It's alleged that she failed to report on a monthly basis, failed to pay fines and costs or restitution, failed to test on demand, and failed to participate in treatment. Basically, we just lost track of her. An arraignment was set for August 15th, and the defendant didn't show up, and a bench warrant issued. And she got picked up somewhere before May 28th. She had been in jail in some other jurisdictions. And Rush County, Indiana. And then she got released from Indiana. Apparently, we didn't have a hold on her. And she got released in December of 25 and was living her life in LaGrange and working. So I canceled her bond and set the matter for a probation violation hearing today. And your attorney, Rhonda Ives, is back with us, and she's been out to the jail to meet with you, which I appreciate. It's my understanding, Ms. Ives, the defendant is going to admit to at least part of these violations.
Yes, Your Honor, she's willing to admit that she failed to appear for probation as directed.
Is that true, Ms. Wilson?
Yes, sir.
All right, I told you this at your arraignment. Let me repeat it here today. You have a right to have a hearing in this matter where it must be established by at least a preponderance of the evidence that you violated these terms of your probation. And as I told you at the hearing, you'd have a right to have your attorney present, and she's here with you. She was your original attorney that worked out this very favorable plea agreement. By entering a plea to that violation, you'll be giving up your right to have a hearing on the violation where it must be established by a preponderance that there was a violation of your terms of probation. Frankly, these aren't going to be real hard to prove. We just lost track of you. So are you here admitting that you violated your probation by failing to report from sometime in August until you got picked up again in May of 2026?
Yes, sir.
The admission we just heard is extremely important. By admitting the violation, the defendant is essentially removing the need for the prosecution or probation department to prove that part of the case at a formal hearing. Judges often appreciate honesty, but admissions don't erase the violation itself. In many situations, they simply move the conversation from "did it happen?" to "what should the consequence be?" That's where sentencing arguments become critical. The court now knows there was a failure to report, and the focus shifts toward accountability, rehabilitation, and public trust. The defendant may hope that admitting responsibility demonstrates sincerity, but the judge will also weigh her actions over time. If you were sitting on the bench, would you view this admission as a sign of accountability or as an acknowledgement of something that was impossible to deny?
All right. You had gone to jail in Rushville, Indiana. And I don't remember if you told me what that was for, but whatever you had in Indiana is done. Is that correct?
Yes, sir.
What was the charge in
Well,
Rushville?
the original charges were stolen vehicle, possession of meth, but none of the stuff that they had found on me was meth. The ending charges ended up being I did 4 months for possession of marijuana.
So that was the charge?
Yes.
Possession of marijuana?
Yes. And I completed all of that.
And if what you told me was correct, you were released from there in December of 25 and then just went back on with your life, got a job, got a place to live.
Yes, yes.
All right, let's go to Daniel's recommendation. This was not a very successful probation. Daniel's recommendation is we simply revoke the probation and impose the deferred days of jail. At that time, there were 81 days left. She's got some additional credit since she got locked up. How
Well,
much jail?
I wrote 81, but I believe technically after the judgment, it says 83.
All right, it was 83 that were deferred.
Right.
How many days has she
And
been?
she's got 8 days credit today, so it would be a 75 remainder.
What's your recommendation? We simply revoke the probation, reserve the restitution, and impose the deferred jail days?
Yes, Your Honor. And I will just say that when I contacted them back in August on 25 Roche County, they said that her charges that they were still working with were at that time possession of meth, receiving stolen property, possession of syringe, and trespassing charges. They also stated that she wasn't going anywhere because of a failure to appear for their court, as well as being on probation and absconding from that for my probation. And that was the situation. So kind of like repeat behavior is kind of what it looks like down there. So I'm guessing that's why she got 4 months for a marijuana charge, if that was the result of it. I didn't call and find out for sure, but yeah. And then she got out the end of last year and had her name changed. She didn't update her change. She just went on with her life. So I don't get the police reports, but I'm assuming since the court gave her that much time that it must have been a serious offense. And
now we're hearing the probation officer's perspective, and it's clear why this recommendation carries weight. Probation officers are often the eyes and ears of the court. Their job is to monitor compliance and report patterns of behavior. What seems to concern probation here isn't just a single mistake. It's what appears to be a repeated cycle of noncompliance, missed obligations, and new legal issues. When probation officers begin describing behavior as a pattern rather than an isolated incident, judges tend to listen very carefully. That's because probation only works when there is ongoing cooperation. The recommendation to revoke probation and impose the remaining jail time suggests probation believes supervision has failed. The question now becomes whether the defense can convince the judge that things have genuinely changed since those events occurred.
It's a serious offense, and I would just defer to the court, but I would say give her the balance.
All right, Ms. Ives, what's your thought here?
Well, Your Honor, my client would like you to consider allowing her to continue on probation. And this would be why. She really didn't get very far when she got released back in July. She hadn't had any substance abuse treatment, had relapsed back with marijuana, was in Indiana. It's still illegal in Indiana. And although there was other various charges, she had pled not guilty to them. She ended up pleading guilty, was sentenced, and obviously not in Michigan for approximately 4 months. When she got out of jail, she realized she really needed to keep substances out of her life. Since she's been out of jail and she's been living in Sturgis with her in-laws, I think it's Sturgis, correct? Yes. She started her own program that she has maintained, and she's been going to Celebrate Recovery on Fridays. She's been doing the Sturgis Missionary Church, the group on Sundays. And she's also, except for a couple weeks prior to being incarcerated because she had gotten a job and was working on Sundays, or on Wednesdays, she had been going to a recovery group for women on Wednesdays. Was it for just for women?
Yes.
On Wednesdays at Destiny Church. And she really was trying to put, I think, you can't help anyone else until you help yourself. And I think she was really, in my opinion, just based on everything she's told me and what she's learned through the course of going through meetings, that, she's had to take this one day at a time, focus on treatment. She was able to obtain employment. She just got her first car in a long time. So she's got a valid license. It's validly plated. It's got valid insurance on it. She has an employer that they're keeping her position for her, at least right now. She's got her first paycheck, and from that paycheck, she's willing to, put, I don't know how much her paycheck is, but, she said she'll have at least $50 that she could pay towards the restitution immediately. She would like the court to consider, you to allow her a chance, even if it's a short-term probation where she could pay off the restitution, show that she's a different person now. And I know that's a lot to ask for, but essentially, a lot, kind of happened rather quickly. And I know that I think the outcome for her was a good plea. And I think she understands that that was a benefit to her. And she also knows that the restitution had to be paid, but she was really in a position that she couldn't do much, just based on her mindset when she was released from jail. And then obviously her subsequent incarceration.
This is a textbook mitigation argument from the defense. Rather than disputing the violation, the attorney is presenting evidence that her client has started rebuilding her life. Employment, recovery programs, church involvement, stable housing, transportation, and plans for restitution are all factors courts frequently consider when deciding whether someone deserves another opportunity. The defense is essentially asking the judge to focus on who the defendant is today rather than who she was when the violations occurred. These arguments can be powerful because judges often want to encourage rehabilitation. However, they must balance that against the need to enforce court orders. Do you believe people should be judged primarily on their past actions or on the progress they've made since then? That's the exact tension playing out in this courtroom right now.
And so that brings us today, but she would like the court to consider giving her an opportunity to show you that she'll pay the restitution in full and that she will comply with Mr. Frazine's reporting requirements and obligations that she would have with his office.
All right, thank you. Ms. Stallard, Ms. Wilson, or Ms. Scare, I'll go with Ms. Wilson. What do you want to tell me?
I mean, a lot has changed for me since August. I've been sober since August, going on almost 12 months, and this has been a roller coaster for me because it's been up and down. But I'm a grandma now, and I'm getting ready to be a grandma 3 times over, and I love my job, and I'm happy that I finally got a vehicle for the first time in 2 years in my own name, and I'm just willing to do whatever, be at the mercy of you. I mean, I understand that this has been a pattern, but this time I mean, it's different for me. I've been doing this on my own since August. And
why didn't you contact Daniel when you got out of jail?
And I know it's not, I mean, it's excuse after excuse. I wanted to get established. I wanted to get a place. I wanted to get a car. I wanted to show you that I wasn't the same F up that I've been my whole life. And I just wanted to show you that I really was honestly going to start making payments as soon as my checks started coming in.
This may be one of the most revealing exchanges in the entire hearing. The defendant is trying to explain that she wanted to get her life together before returning to court supervision. From her perspective, she may have believed showing results would speak louder than promises. But judges often see things differently. Courts expect communication, especially when someone is on probation. Even positive life changes don't usually excuse failing to report. What's fascinating here is the clash between personal reasoning and legal responsibility. One side sees an effort to rebuild. The other sees someone making decisions without court approval. This disconnect often determines the outcome of probation cases. Was she genuinely trying to prove she'd changed, or was she avoiding accountability until she felt ready to face the consequences?
My checks started coming in, and I just wanted to show you that it was different this time than any other time. Me just telling you whatever you wanted to hear.
Which I think is what you've done. I think you got a big, large streak of con man in you. This was a bad crime. You stole all this money from the guys at the American Legion who trusted you with that job. You didn't just steal it once, you stole it multiple different times. Then you went into the building, you drove in there at night with your car, went in there, stole some stuff, lied repeatedly about it, till you finally admitted, it wasn't me, it wasn't my car, that's not me. Well, it was you on the video, it was your car or somebody's car you were borrowing, and finally you admitted it. You remember, it was in the old courtroom, all the guys from the Legion were in there, and it was in part because of them that you got this sweet plea agreement. This was a felony, it was a clear felony, it was a breaking and entering, or at least a larceny of building. You went in the building at night and stole from them. And when you were working, you would steal money from them and the lottery. There were probably 8, maybe 6, at least different incidents where you stole money. So it should have probably been a felony. You wouldn't have gone to prison, but you would have had a felony. So it was instead a 90-day misdemeanor. So I held a large portion of jail over your head. And the guys from the Legion were very generous toward you, and you paid them back by doing 0 on your probation, going to another jurisdiction with a needle in your car, going to jail, getting out of jail, never calling your probation agent or doing
The judge's
any
comments
effort.
here reveal exactly what's driving his decision. This is no longer just about missed probation meetings. The judge is revisiting the original offense, the plea agreement, and the trust that was extended at sentencing. Judges remember when they give someone a significant break, and they often expect that opportunity to be respected. Notice how he repeatedly references the generosity shown by both the court and the victims. In his view, the defendant wasn't merely non-compliant. She failed to honor a second chance. Whether you agree or disagree, understanding the judge's mindset is crucial. He's evaluating credibility, accountability, and respect for the court's authority. Those factors frequently carry just as much weight as the technical probation violations themselves.
Or doing any effort to repay it. So I don't know who you are now. It seems like a better person you were then, but the person you were there then was not very good.
No.
And you didn't do anything that I asked you to do, ordered you to do. So you've earned this. I'm going to order 93 days jail credit. How many is that? 93 2, 93 minus 75 is 18 days jail credit. Leaving 75 days jail to do. You'll get 5 days a month good time. If you're on the path that you're on with your own self-motivated recovery, I don't need you on probation. But this offended my sensibilities. You got a super sweet plea agreement. You got a very generous sentence by me, and you paid me back by this. So I'll reserve on the restitution, which was $1,200. So if all those things are true, $1,250 restitution to American Legion.
The ruling
So
is becoming clear. Although the judge acknowledges positive changes in the defendant's life, he ultimately concludes that consequences are still necessary. This is something many viewers find surprising about the justice system. Rehabilitation and punishment are not always mutually exclusive. A court can recognize someone's progress while still imposing a sanction for past violations. In this case, the judge appears to be sending a message that accountability matters even when improvement occurs later. At the same time, notice that restitution remains in place, meaning the obligation to repay the victim survives the probation revocation. That reflects another key principle of the court system, making victims whole whenever possible. Do you think this balance between accountability and redemption is fair?
So you'll still have an opportunity to pay it back, and your probation is revoked. at which point you can really start fresh. I won't be supervising you, won't be looking over your shoulder, but I told you what was going to happen at the time of the sentence, and it just happened. I'm disappointed, but I'm, I guess, encouraged that you're in a better place today than you were then. But you got 75 days to do, and you still owe $1,250 in restitution to the American Legion, and your probation is revoked.
One
So when
subtle
you're
but
done-
important detail is the judge's final tone. Despite his frustration, he doesn't end the hearing with anger. Instead, he expresses disappointment while also acknowledging that the defendant may genuinely be in a better place now. That's a reminder that courtroom decisions are often more nuanced than they appear. The judge isn't necessarily saying she can never change. Rather, he's saying the consequences for violating probation still need to be served. After that, she can move forward without court supervision hanging over her head. These moments highlight how judges often try to balance public accountability with the possibility of personal growth. It's a difficult line to walk, and reasonable people can disagree about where that line should be drawn.
So when you're done, we'll be off your back. All right, good luck to you.
Hey, Rhonda, how you doing? Are you gonna come to our golf outing? It's Friday the 19th.
Maybe,
If
I don't
If
know.
you don't show up, you might be the secretary of the bar.
Yeah, that's a good plan. If you don't show up, then you get nominated as a court officer.
I just don't golf very well, that's all.
Well, I go, but I don't play golf. I just go for the luncheon
And the appointments.
and the appointments. We actually have a bar meeting at that session.
All right, I'm going to put it in my calendar. What golf course are we
It's at
at?
Saguenash.
Same one we were last year.
Oh, okay.
I mean, even if you just wanna come for lunch.
Oh, I do, I
Just wanna
do.
make sure it's not nominated.
You see, she went through our email blast and
Yeah,
cleaned all that up. Hey, Laura said to me.
yes, thank you. I wouldn't have set this for 11 o'clock. Let me close out the live feed and
What a fascinating case. This hearing centered on a defendant who originally received a highly favorable plea agreement after theft-related allegations involving the American Legion. Instead of completing probation successfully, she admitted to violating the terms by failing to report and effectively disappearing from supervision. The defense argued that she had transformed her life through sobriety, employment, recovery programs, family support, and a renewed commitment to responsibility. However, the judge ultimately focused on the original opportunities she was given and the court orders that went ignored. In the end, probation was revoked, the remaining jail time was imposed, and the restitution obligation remained intact. The ruling sends a clear message that courts expect compliance when second chances are granted. At the same time, the judge acknowledged the possibility that the defendant's life may genuinely be improving and expressed hope that she continues down that path after serving her sentence. Now, we want to hear from you. Did the judge make the right call, or should the defendant have received another chance to prove she had changed? Share your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.